ready to, yeah. All right, everyone, we are up and running on our civil docket here in Berrien Circuit Court. I would want to ask any of you if you have occasionally on Monday mornings, you're doing two calls at once or have a judge in another place that's chomping at the bit, and he or she's probably going to get madder at you than I am. So if you need, somebody needs to go first, let me know. If not, I'm just going to peruse, go through these files here in kind of a chronological, reverse chronological type of situation. My first case that I would have, my oldest case, is 17 CI 352. That's Houchins versus Dollar General, which I see Miss Worley, but I don't see Mr. Gillenwater.
Good morning, Judge. Langdon Worley on behalf of Dollar General. I spoke with Mr. Gillenwater's office on Friday, and he advised that he was not going to be attending, but let me know that he was agreeable to certain pretrial dates if we wanted to go on and set one.
Okay, just tell me what you have in mind, if you don't mind, and we'll see if we can all make it work.
He was looking at Judge August, I believe, which seems a little far out to me, but I'm agreeable to that just to get something on the calendar to get it moving.
All right.
And he said Monday, well, actually he said Mondays in July or August will work for a pretrial conference.
Okay. And are you expecting, are you wanting some deadlines of some sort that are going to be tied into that, or is that just something that you all want to have something to shoot for?
Well, Judge, I actually haven't had the pleasure of practicing in front of you before, so I wasn't sure if you had a standard scheduling order that you entered or what you would suggest.
Well, I normally have a scheduling order that I enter in the context of just setting a trial. And the problem in this situation is that usually when I set a trial, it would be, the pretrial probably wouldn't be that close. I mean, the pretrial would usually be 6 or 7, 8 months out, something like that, because I set it pretty close to the trial. As you can probably imagine, trial dates, in civil cases or slip and fall cases, whatever, they're kind of hard to get. It's hard to get one on the immediate horizon just because of all the other in custody trials and child victim trials and murders and things of that nature that have backed up.
Right.
So my point being, if I was setting a pretrial, I usually just set that along with a trial. And in this situation, it would be way out. I think probably as old as this case is, you'd probably want a date sooner than that with some kind of something, some teeth in it.
That would be ideal, Judge. And I'll tell you, in this one, we were before the court in December. We've mediated. I've deposed the plaintiff's treatings. We've really reached the end of our rope as far as negotiations. Mr. Gillenwater advised he's now got additional records related to what he claims is related treatment. So it's just kind of a repeated situation here that we're dealing with. I would be completely fine to get a pretrial date in July just to get the two of us in front of you so we can talk about where we are, see if these additional records and bills come to fruition by that date, and then see what we can do to get it moving. Just kind of at the end of my rope at this point.
Yeah, I understand. And I remembered being here 5 months or so back, and you all had talked about trying to get it mediated. And so I assumed that had not been fruitful.
We did mediate it.
It didn't work out.
That's right. That's right.
Yeah. All right. Well, why don't we do this? Why don't I set a pretrial conference? I know you don't want to wait too long. The flip side is the later we set it, the more likely that everything's going to be everybody's more ready to come back in person. I know Tim's got a lot of health issues, and that's what's kept him from wanting to, among other reasons, kept him from wanting to be out in public very much. I think if we set it like that first Monday in August, that might be the best thing to do.
That sounds like a plan to me. That
Because I mean,
works.
any rule that we have about meeting in person and remote, it'll probably start, at the beginning of a month. So, I mean, if we did it in July, I really don't think things will be a lot different in July than they are right now, which is, we're being told from the Supreme Court not to meet these things in person unless we just feel like we have to.
Sure.
So let's try August 2nd. How about that?
That works for me. And that will be at 9:00 your time, Judge.
Yes, ma'am. Yes, ma'am.
And at that point, I presume we'll stick with Zoom unless anything changes.
Yeah, if we'll try to get word out to everybody if we're going to be meeting in person.
Great. Thank you,
But I
Judge. Would
think
you like
that's
me to tender an order?
Did you tender one electronically when you filed the motion? I can't remember.
I would doubt that I did, unfortunately, but I'm happy to do one today.
Yeah, if you want to tender one, just put one in the e-filing. That'd be great.
Okay. Thank you, Judge. I appreciate it. May I be
Thank you.
excused?
You bet. Thanks.
Bye.
I'll keep that just in case. Next case I have, and I think this case has been renoticed, but I'm going to call it just in case, is 19 CI 280 Jones et al. Versus Hicks et al. I believe we got a motion, a renotice of that this morning, right? Okay. 20 CI 114 US Bank versus Cowles.
Good morning, Your Honor. Robin McDonald here for the plaintiff. It's our motion to substitute real party and interest. We had an investor change, so we are going to substitute the plaintiff. I think there should be the appropriate launch and AOM attached.
Yeah, I believe there is an order here that we can enter and should kind of get things taken care of.
Thank you, Your Honor. That's all I have. May I be excused?
You bet. Thank you.
Thank you. Have a nice day.
That's e-filed. All right, next. Okay. I've got 20 CI 354. That's Nicole Jones versus Gary and Julia Jones. Gary and Julia Jones versus Jimmy White. Anybody here for that?
Yes,
Your
sir.
Honor, Elizabeth Bass here for the defendants, Gary and Julia Jones.
And Judge Brian Driver here for the plaintiff, Nicole Jones.
Okay.
I believe this was Mr. Richardson's motion. He's representing the third party defendant.
That is correct.
Yeah, I don't see him on here.
And Judge, in my response, Elizabeth is correct. I filed it Friday, and it was a little bit difficult conceptually because at first I joined Mr. Richardson's motion for summary judgment against the third party defendant, but then I raised a new separate and distinct issue as far as what Nicole Jones was saying as a reason for third party summary judgment against the third party defendant. So at that point, it became a motion for summary judgment, which was not noticed for this Monday. So I'm going to have to renotice that because it did not comply with the 10-day rule. So it's kind of like I started briefing my reply and then turned it into my own motion.
Yeah. Yeah.
So it is what it is.
So I'm looking at the defendant's objection to your part of your response, at least, and that's what she raises as well. So, let me ask you this.
Yeah,
and
that's
Richardson,
correct. I mean, she's right.
Yeah.
Yeah.
Since we don't have him on here, I mean, would you all object to me just setting this out like 2 weeks or so, and that way everything ought to be timely at that point?
Well, Judge, here's the only thing from my side where, there's kind of an issue where whether or not I may need to take Gary Jones's deposition. He has stage 4 cancer. So kind of, Elizabeth and I are going to have to talk about that. So as far as my motion, I would request that I may have to renotice that further out than 2 weeks. But as far as Mr. Richardson's, they're really separate and distinct, but they're kind of combined also because we're going after the same third party, defendant and trying to have that claim thrown out on summary judgment reasons.
What if for now we postpone it 2 weeks and then we can confer and we may agree to set it out for a different date. But I think for our purposes this morning, setting it out for the next motion hour or at the court's convenience would work. And then we can confer and maybe have a better idea of what our specific plan will be then.
Yeah, I mean, if we just have some sort of some sort of plan moving forward,
Okay, sure. That's agreeable.
that would be good
Yes, sir.
from my standpoint.
Okay.
Because these things start to get kind of complicated when you've got a lot of different parties, and I need to make sure that I know what I'm being asked to decide and what I'm not being asked to decide. And at the very least, if yours is not mature yet and Mr. Richardson's is, then you all can tell me that and I can sever out those issues and, decide one. And then if however it is going to affect the outcome of the other one, we can wait and see.
Yes, sir. That makes sense.
All right. So 2 weeks, does that work for you all? 1 or 2?
2 would be better. That would probably give us more time to see what we're going to do.
I can live with 2.
Thank you, Your Honor.
So that is the 17th, right? 17th at 9:00.
Yes, sir.
We'll just do we'll do an order real quick so that nobody has to file anything. Okay?
Thank you, Your Honor.
All right.
Thank you, Judge.
Thank you. Garner and Garner versus TJ Sampson and Thorpe.
Good morning, Your Honor. David Gray here on behalf of the plaintiffs. This is my motion to compel defendant TJ Sampson regarding some discovery. By way of history, Judge, the discovery was sent out 8 months ago, back in September. I asked you in December for some help, which you gave me. In January, the hospital sent me their responses, which were, in my view, incomplete. I've sent 2 emails being specific about interrogatory number 28 and 3 requests for production. All 3 of my emails have gone unanswered. So I'm once here before you asking for your assistance to compel these answers. The only interrogatory I'm pressing on is number 28. It regards forceps, what was available in the hospital. That's the crux of this case, Judge. And then the request that I'm pressing on to get answers to or production from are the policies and procedures regarding the operating room, labor and delivery room. So it's been 8 months. I've already been in front of you once, and I'm here again, just trying to get some responses, Judge.
Understood.
Morning, Your Honor. David Giesel, covering for David Thompson on behalf of the TJ Sampson defendants. We would just ask for 2 weeks to respond. I know in the order it said 7 days. We just asked for an additional 7 days. We're working on getting that information from the hospital.
Well, if I do that, and Mr. Gray still doesn't have anything after 14 days, he's going to be even twice as mad as he's going to be that he's had to come in and ask for this. Is that fair to say, Mr. Gray?
That's a fair statement, Your Honor.
Mad might not be the right word, but frustrated might be the.
I'm apparently a fairly reasonable guy because it's been 8 months, and
yeah,
I'm not asking for cost or anything. I just want to get the answers, Judge.
Yeah, I don't think you're being too hard to get along with, since you weren't asking for any sort of sanction type of outcome. You just want your info.
Right.
And I'd probably be willing. I mean, just in this day and age, I understand that a week is kind of hard with people. Some people working in offices and some people working from home and yada yada yada. I mean, I understand all that. I'd be willing to give you 2 weeks. but I think that it's important to, I don't know anything about any conversations that any of you all have had, but I think I do remember this coming up several months ago, and I think that, you know, plaintiffs are entitled to get what they're asking for. Okay.
Yeah, and
And-
Judge, the last, and what may assist you, I have the first deposition of the first nurse coming up on the 24th of this month. So the sooner the better. If we keep pushing this out, I'm coming up against this deposition.
What day is that? 21st,
The
24th.
24th? I tell you what, why don't I say that this will have to be to you by the 14th, which is almost 2 weeks, but it's more like, I mean, it's the Friday before. 2 weeks would be a Monday, so it's the Friday before that.
That's fine, Judge. I appreciate your help.
Just
Thank
to
you,
give
Your
you
Honor.
a little bit more time to, you know, to peruse what you need to go through before you take this depo. Okay.
Thank you, Judge.
All right.
Thank
You have tendered an order, and yeah, I can just fix that from. I can just fix that to put a deadline, put May 14th on it.
Thanks again, Judge.
All right. Thank you.
Thank you, Your Honor.
Scotty's Contracting and Stone versus Wilkerson.
Morning, Judge. This is Justin Duncan on behalf of the plaintiff,
Yes, sir.
and this is our motion for summary judgment.
Mr. Basil, are you on the other side of this?
I am, Your Honor. Do you want us to do oral arguments on this, or do you want me to simply submit a brief on it?
Well, yeah, we're not really going to have time to do much arguing and unless you all wanted to do it on a different day. I don't know that it should take much in the way of argument. But I would listen to what you all had to say if you wanted to take the time to say it.
I'm fine with briefing it. I believe he's already briefed his side of the argument. So if you'll just give me a short deadline, I'll have a brief to you on it.
Yeah, the plaintiff's motion is pretty thorough, and it's backed up with citations to law and argument and an affidavit and all the good stuff. So I could give you a little bit of time if you wanted to respond to it. And
If you just want to give me 10 days, that's fairly standard. And then he may want a rebuttal. I don't.
would you like
Yes,
a
Your
little
Honor.
rebuttal time? 7 days?
7 days is fine, Your Honor.
All right. So reply or response within 10 days, reply or rebuttal within 7 days after that. And then we'll go from there. It could be a deal where I feel like I need to hear from you all. That has happened before. Generally, if that happens, that may mean that there are factual issues that need to that preclude summary judgment, but it doesn't necessarily mean that. I mean, it might mean I've had situations where I've said, after reading everybody's briefs, I need to get everybody back in here where I can ask you guys some questions. So that could happen. And if that happens, we'll get in touch with you and set like a non-Monday, set it on an off day where we got a little bit more time to talk about it if that eventuality presents itself. Okay.
Yes, Your Honor.
I don't expect it, but all right. We'll get an order out with those deadlines in it. Okay.
Thank you, Your Honor.
Thank
Thanks,
you.
Judge.
Williams and Williams versus Patrick.
I'm here on behalf of the plaintiffs, Your Honor.
All right. Mr. Peck, this is you have a judgment, right? I'm trying to summarize. You have a judgment. You tried to do a post-judgment deposition.
That's
didn't get-
correct.
And the defendant didn't attend.
Yeah, we had him served, Your Honor. Ms. Reed served him on March 24th to attend the deposition. He chose not to attend. I had Mr. Redford here. We put on the record that he did not show, and I think Mr. Redford was very reasonable in his cost of $73.60 is all he charged. So Your Honor, I'm not sure what your normal procedure is when someone doesn't show when they've been subpoenaed, but obviously I want to encourage Mr. Patrick to show up at the next deposition when I schedule it.
Yeah, I agree.
I want him to be incentivized properly.
Yeah, and Mr. Peck, it's a lot harder when you don't have somebody standing here in front of you, where you can kind of look them in the eye and explain to them what will happen. I think, in the light of where we are in the world right now, what might be a good idea would be to enter an order. And the quickest way to do it would be for me to kind of tell you what the order needs to say and you to prepare it.
Okay.
Because I'll be in court all day for the next 2 days. But I think that you can say in the order that that the defendant has failed to demonstrate any good cause why he should not be held in contempt for not attending the deposition. And then just put something to the effect of, the plaintiff shall schedule another deposition, and if the defendant fails to attend without good cause, he'll be subject to all of the sanctions available to the court, including but not limited to costs and a fine and possible incarceration.
Okay.
Something along those lines. It doesn't have to be verbatim.
Okay.
Before you tender it, before I sign it, and if I don't like what it says, I'll change it or send it back. But I think you know how to do it.
Sure. I'll get it typed up and tender it to you in a Word document. And you massage it any way you deem appropriate.
Yeah. And you're gonna, what the possible sanctions are for contempt. So I want to, I want him to be made aware of the full panoply of possible outcomes, because that's what I would be telling him if I had him standing here and was able to look at him and say, you could go to jail for this, or you could get fined a big amount of money, have to pay Mr. Pack's attorney fee and pay the fee for the court report. That, I would tell him all that.
I almost charge as much as Tom Carrick. Not quite as much, but almost, and that's enough incentive right there to get him to show.
Hey, you know what? That almost is where that's where the difference is.
Yeah.
Yeah. Yeah.
I may go ahead and put the deposition date in that order, Your Honor. I may just select one and put it in there.
Yeah, that would be fine. Whatever day that as long as it's not, this should go without saying, but I guess since we're putting everything on the record, as long as you don't set it at some kind of, weird weekend time or something like that.
No, I'll probably put it a month out just to make sure he's got time to get the order.
Yeah, ample time. And then theoretically, it might be best to follow up with getting him a notice in person as well of the depot.
Gotcha.
Because then you're going to have somebody signing something saying I handed this to him.
Yep.
And if they had a copy of that order, they can hand that to him too, after it got entered.
Okay.
You want to use belt and suspenders, that way you're positive your pants aren't going to fall off.
Yeah, understand.
All right.
All right. Thank you, Your Honor.
Thank you. All right. Bull et al. Versus Brad Reagan Recycling.
Yeah, Judge, Tom Carrick here for plaintiffs, the Bull et al.
Aaron Smith for the defendants, Your Honor.
Okay.
This is a motion for partial summary judgment, but we were advised yesterday that the defendants have filed a bankruptcy petition.
I was advised just now about that same information. My clerk just handed it to me.
Yeah, right. So
you
I
all
guess
should have just told me to call your case first.
Well, that's all right.
You wanted to listen to all that scintillating argument on.
Hey, I miss motion hour. I used to always learn more law at motion hour than I did anywhere else.
That's right.
Well, times have changed.
They have.
If you take today as an example, at least times have changed. None of us learned anything today.
Yeah, that's right. But I guess we'll all be just on hold, Judge, until we get something worked out on this bankruptcy.
Yeah, just you all know how to let me know if there's anything we can do.
We'll do that, Judge.
All right. Thank you.
Thanks, Judge.
Graves Gilbert versus Ballard. That's not right. What's happening? Hold on. I have Graves Gilbert versus Ballard is 21C 111. This motion has been filed in 21CI 111, and everything that's been filed in this case has been filed in 21C 111 instead of the, good Lord. Everything.
Everything?
Yeah. This is what's left of that file after I take the wrong paperwork out of it.
Well, wait a second.
And I mean, heck, Mr. Reynolds is the one who filed the motion, and he's not on here, so. Is it?
So I wonder if everything in 21CI 111 is filed in 21C 111. If all that paperwork is the C case, right?
It's possible, but it doesn't look like there's anybody here for it anyway. So I'm just going to say no one appeared for the hearing and it can be renoticed. We can probably do that, can't we, Kirsten? Yeah. All right. Bobby? Oops. Can you hear me?
I can.
All
I
right.
just now got on and I could never get on the Zoom. I guess
Yeah.
you had to hear it without me.
Well, what they talked about was apparently Brian filed some sort of response, and part of his response, he jumped on and supported you, and then part of it, he raised some additional issues, and I guess the other party objected to him raising his additional issues, but they said that, you know, if he gave 10 days notice that we could hear it all at once. So they asked me to pass it for 2 weeks and just put it on for the 17th and decide whether or not we were going to talk about Brian's motion and your motion, or just hear your motion and not hear his motion, or, you know, it started to get complicated.
Well, that's probably, if I'd have been on it, it'd have been worse complicated.
The more talking, the worse it was.
So I'll just, I appreciate it. Will we be on this same site for criminal court at 10?
Well, if you want to come in person, you can come. If you and your client want to come, and if we'll have the Zoom going too, so we can do it both ways.
I'm just gonna come up there then. It's a hell of a lot easier figuring out this Zoom.
What we've got it worked out to where people, because I've had a lot of attorneys and the defendants too tell me that they want to come in person. And I figure if they're asking, I'm going to say yes, because we're allowed to say yes, you know, case by case and so on. And so we'll have it where we can do the people that aren't here and the people that are here. You know, I've got a monitor set up and everything. So it'll be okay either way. I don't want to force anybody to come in that doesn't feel comfortable coming in, but I know that almost everybody, all the lawyers that I've talked to a person, except for one, have said, you know, have been saying for months that they want to come back up here. And I mean, all the defense lawyers, all the plaintiffs, Commonwealth lawyers, everybody. Yeah. So
I'll be there at 10 o'clock.
All right. Thank you.
Thank you.